Man, so there is a really, really crazy Supreme Court case that just came out. I don't know if it came out today or yesterday, but either way, regardless, it had just come out. But basically, what it is doing is it's actually really curtailing the right of somebody who is actually innocent to be able to claim their innocence post conviction by making a claim of inadequate counsel, like inadequate legal defense that is appointed by the state. So you guys know the Sixth Amendment of the United States Constitution guarantees you a right to assistance to counsel to defend yourself. That is a positive right that's given by the Bill of Rights. And so you are guaranteed in a criminal trial legal assistance from a public defender, right? So that's in the Sixth Amendment of the Constitution. Now, what happens when the lawyer that you're appointed by your opponent, by the way, because your opponent is the state. So it's actually funny when you think about it. It's like your opponent is giving you your legal counsel. That's kind of funny. Anyways, what happens when the legal counsel that your opponent is giving to you is woefully inadequate and doesn't do anything, or misses out on a ton of evidence that they could have easily put out there, or they could have put out there to show your defense and your innocence? Well, previously, it looked like the Supreme Court and things like that had determined that it's not the fault of the person who is being defended by the counsel, but rather the counsel itself. It's not the job of the person to defend themselves, but rather the counsel. That was, I think, a 2012 case that had, so it was like 10 years ago. It's not that much precedent from that case specifically, but that was the idea. But now what the Supreme Court has said is it's actually not enough for there to be evidence of innocence for there to be a claim of new necessary illegal counsel assistance that is done in the federal courts on the state level. So you'd be appealing to a federal court to be able to get more another lawyer, another legal counsel. So this is dealing with the specific case. Okay, it says last December the Supreme Court gathered to hear oral arguments in Shinn versus Ramirez, a case that can mean life or death for Barry Jones, who sits on death row for the rape and murder of his girlfriend's 4-year-old daughter, Rachel. So this is a really horrible, tragic situation. This is a really extreme charge, obviously, the biggest charge you can possibly get. What's worse than rape and murder, right? Of a 4-year-old, literally. So this is a huge, huge case. But here's what it says. It says, in 2018, a federal court overturned Jones's conviction, concluding that he had failed to receive effective counsel, a violation of his Sixth Amendment rights. Had that happened, a federal judge ruled, there is a reasonable probability that his jury would not have convicted him of any of the crimes with which he was charged and previously convicted. After losing in the Ninth U.S. Circuit Court of Appeals, Arizona's Attorney General appealed the decision to the Supreme Court. During those oral arguments, state prosecutors repeatedly argued that, quote, innocence isn't enough of a reason to throw out Jones's conviction. So you can't just say that, he's innocent and therefore it needs to be thrown out because the legal counsel wasn't good. I guess you would have had to have showed some kind of other failings in the court instead. I don't know, maybe like... I'm not sure, just judicial misconduct of some kind, I'm not sure. It says, on Monday morning, by a 6-3 vote, the Supreme Court concurred Barry Jones's innocence is not enough to keep him off of death row. The state of Arizona can still kill Jones, even if there exists a preponderance of evidence that he committed no crime. So remember, you have to prove in a criminal case, you have to prove beyond a reasonable doubt. The standard in a civil case is preponderance of the evidence, which is a lower bar for convicting someone, because in the United States, people take very seriously, the idea of an innocent person being convicted for a crime that they did not commit. Says the crime for which Jones was convicted is horrific. The little girl Rachel died from peritonitis. Never heard of that. The result of a rupture in her small intestine that the state of Arizona claimed came from repeated physical and sexual abuse. But Jones's lawyers never questioned the physical evidence that led to his conviction. As Liliana Segura, an investigative reporter for The Intercept, pointed out in an exhaustive piece last year, quote, had Jones's lawyers been up to the task, there was plenty they could have done to defend their client. They could have pointed out that the lead detective who examined Rachel at the hospital didn't bother to investigate how or when the child sustained her fatal injury, or consider a single other suspect aside from Jones. They could have called a medical expert to show that there was no real evidence that the child child had been raped. Most crucially, Jones's lawyers could have called a pathologist to challenge the state's theory of the crime, which rested on a narrow time frame during which Jones had supposedly assaulted Rachel the day before her death. Medical experts now say that Rachel's abdominal injury could not have become fatal so quickly. So basically what this is saying is there's a bunch of evidence that he actually is not the one who murdered Rachel, and I don't even know where they got the rape claim from. I'm not sure what the evidence that she was raped is. I'm not sure where that even comes from. But there's evidence that basically would have taken like at least more than 48 hours for the abdominal injury that Rachel sustained to kill her, and he was taking care of her, I think, like maybe within the 24 hours before she died. So literally medically would have been impossible for him to have committed that murder. Also, I think her mother was also in prison. I don't know if this was in the same case or a separate case, but for abuse. I don't know if it was also sexual abuse, but definitely physical abuse of her daughter. And I guess also it said that her brother said that, he was interested in basically like sexually abusing children. So you kind of already have like a likely suspect going on there, and this does not seem to be this Jones guy. It says at the time of his trial, Jones was appointed a lawyer by the state, a fundamental constitutional right guaranteed to all criminal defendants under the Sixth Amendment. If a defendant argues after conviction that they failed to receive adequate counsel, they are appointed new legal representation. If the new lawyer also provides ineffective counsel, a federal habeas appeal allows them to argue that their post-conviction lawyer was ineffective. So you're basically petitioning federally that your post-conviction lawyer was ineffective. And then basically they end up looking at it and say, okay, well, let's see what evidence could have been presented by the legal counsel. And I think this is how it goes. And this is what happened in the 2018 case, which is this case. Basically, you look it over and say, okay, would this evidence have been enough to actually overturn the case and prove his innocence? If so, then you are granted new legal counsel again. It says, in effect, Jones argued that he received ineffective counsel not once but twice, and the fault lies not with him but rather with his lawyers who were appointed by the state of Arizona. By allowing him to introduce evidence of his innocence, a federal court would be in effect rectifying the mistakes made not just by his lawyers but by the state responsible for appointing them. It's also funny, like I said, like your opponent is giving you the legal counsel. It's like a conflict of interest there. This is in a 2012 case, Martinez versus Ryan. The Supreme Court ruled that a convicted defendant, quote, is not at fault for any failure to bring a trial ineffectiveness claim in state court, and thus open the door to appeals like the one brought by Jones. These appeals should definitely be allowed. I mean, if you have ineffective legal counsel that would have proved you innocence, that's not at your fault. That is a fault of the legal counsel. And so if it is going to prove your evidence, and again, you should be able to file that, federal, habeas appeal. And in that appeal, you can state like, oh, this is the evidence that wasn't shown. These are the experts could have brought in to prove my innocence, and none of this was done. And the judge looks it over, it's looked over, and if it is deemed to be like, yeah, there is a lot of evidence that could have had a probable cause of overturning the conviction and proving me innocent, then that should be allowed. You should be able to get new legal assistance, right? It says on Monday the court gutted the precedent established by Martinez, although the Martinez precedent is 10 years. I mean, it's not that long. It says, in its decision written by Justice Clarence Thomas, the court ruled that a federal court may not conduct an evidentiary hearing or otherwise consider evidence beyond the state court record based on the ineffective assistance of state post-conviction counsel. In short, a convicted defendant like Jones can be held responsible and kept in prison if a state-appointed lawyer provided ineffective counsel for his appeal. So, how can a defendant argue ineffective counsel if they can't point to specific examples of that ineffective counsel? How else can they do that other than by introducing new evidence not presented at trial, which would have likely acquitted them? Thomas is saying, in effect, that a petitioner has to rely on the record of a trial in which they were ineffectively defended, and their actual innocence is one of secondary importance. So there would have had to have been other ways to be able to, get... I'm not sure if there would have had to have been other ways other than potential innocence to deem whether your legal counsel was good enough or not. That might be what I guess Clarence Thomas is trying to say. It says, Thomas justifies the court's decision by arguing that federal review imposes significant costs on state criminal justice systems that include potentially overriding the state's sovereign power to enforce societal norms through criminal law. So again, this is like one of those things where it's more It's more state versus federal again, because this is a federal appeal that's going on, the federal habeas appeal to get new counsel. So this is obviously something in which it should be allowed for that overriding. I guess he's kind of siding more with the 10th Amendment over the 6th Amendment. Although he might argue that the 6th Amendment doesn't say, and this is what the article goes on to say, it's not clear whether conservatives believe in effective counsel, effective assistance from counsel, or if they just believe in any counsel you're given. Again, by your opponent. You're being given counsel by your opponent. So there's already like a conflict of interest going on there, because the person that's prosecuting you is giving you your counsel, right? The state is the one prosecuting you. So obviously this is a situation where I think they probably don't even agree with the idea of effective counsel in the first place. I don't think. It says, as Justice Sonia Sotomayor noted in her dissent, the court decision will leave many people who are convicted in violation of the Sixth Amendment to face incarceration or even execution without any meaningful chance to vindicate their right to counsel. She called the ruling perverse and illogical, which doesn't really do justice to its utter obscenity. So basically, there's a bunch more. Says this UCLA law professor said, to me, part of the problem is courts of a conservative majority does not fully accept the idea that there's a right to effective assistance of counsel. One could argue there's a cost for the lack of finality from new claims brought up by habeas. Every prisoner can just file a new motion to say I was denied effective assistance. So do we as a society want to pay that price to make sure innocent people don't get killed? Not for these guys so much for the right to life. So, this is a really, really crazy, truly crazy situation where if you are given you don't have money for legal assistance. Legal assistance is obviously very expensive. And your legal counsel, which you're guaranteed by the Sixth Amendment of the United States, does not do a good enough job, potentially doing nothing in your situation. And that's not to blame the public defenders, because public defenders are woefully overworked and underpaid. So it's not necessarily to blame them. But if you are in a situation where your legal counsel has lots of opportunities to prove your innocence and decides not to, and you then petition to your federal habeas appeal in the post-conviction assistance, that post-conviction assistance wasn't good, you're screwed. Basically, the Supreme Court says, no, you're screwed, you're convicted, there's nothing the federal court can do, because that's basically violating the state's rights, and we can't have the federal government intervening in the state's court business and what they're doing. So this is really crazy. So it means a bunch of people who are innocent are going to end up being killed on death row or held in prison, because they're basically saying that evidence of innocence is not enough to prove ineffective legal counsel. And not only that, but it's not really clear if this conservative majority court even believes in effective counsel, period. They might just say, oh, well, it just says counsel, so all you need is just legal assistance. But obviously this, habeas appeal should be allowed. This is an area where it's important for this overturn to happen, because the federal government needs to make sure that the Sixth Amendment is upheld through the interpretation of effective legal counsel, because the whole goal of the assistance of legal counsel is to ensure that people who are innocent are able to, defend themselves. And so by extension, this should be allowed as well. And this is really scary, because this is the kind of stuff that we're going to see from this court. And those 3 justices that Donald Trump appointed to the court, man, I mean, this is about to be absolutely awful. And just how these rulings are just going to be coming in left and right. I don't really know how we're going to be able to make it through all of this, because this is it's going to be left and right just constantly. And it can lead to, usually, you have like era courts, like the Lochner era court or whatever, or, like the post-New Deal era court. So we might be in for like a 30-year court strain, or court, type, essentially, is what we might be into. So who knows what's going to happen, but what I have to tell you is it really is not looking good. So this is very, very unfortunate.